but that person gets $100,000 cash surety bond. I none of this. I'll be honest with you, and again, I'll listen to you, but I'm telling you from where I'm starting. None of this makes any sense to me.
People, you're not concentrating on behalf of Mr. Floyd, who I believe is attending via Zoom.
I realize we were notified that you were being appointed to the case last night, but I don't know. Are you prepared to address the issue of bond at this time? Or
I am, Your Honor, for the
All right.
following reasons. First of all, the standard, we all know what the standard is. Okay, so, and then I did have an opportunity to speak, to my client's mother and my client. So we are, ready to prepare.
Go ahead.
So you'll understand that the standard here, I'm sorry, I didn't ask my arguer at the table.
That's right.
Okay, thank you. Abuse of discretion. And that is abuse of discretion happens when it is manifestly unreasonable, arbitrary, or based on a clear error of law or fact, rather than merely being a decision an appellate entity such as yourself would have made differently. The standard recognizes that the magistrate had firsthand knowledge of the case, including arguments made by both sides of.
Before you go on with that, understand that, as is customary for me with these motions, I have reviewed both the swear to video as well as the arraignment video. So I am very well aware of what the magistrate was seeing, but you may go ahead with your.
All right, then I'll skip that. Okay, so it's my opinion that based on it, the magistrate was in the best position. He had all the facts to make a decision.
That this defendant actually pointed a pistol at the person, then struck the person with that handgun and took the phone. And this defendant did all of that. He has a PR. The other defendant who was standing there equally is liable for what's going on. But that person gets $100,000 cash surety bond. None of this, I'll be honest with you, and again, I'll listen to you, but I'm telling you from where I'm starting, none of this makes any sense to me.
Well, I can appreciate the court's candor. The court's going to make their decision, and you know that's the court's prerogative to find an abuse of discretion. I mean, I don't have information as a swear to. I don't have the $100,000 bond that was set on the co-defendant. All I can say is that I believe it was Magistrate Odatello made that call, and he had the information. He had all of this information, I presume, because I haven't seen that video. I'm assuming, and maybe I'm incorrect in assuming, but he made that decision based on the information that they have. Now we're here, and if the court feels it's an abuse of discretion, it's within its power to do so. I'm saying that.
Because it is my birth, Your Honor, I just have a couple of more things I'd like to point out for the court. I want to make sure it's very clear. This firearm was a BB gun, it was a pneumatic gun, but it is incredibly realistic looking. I would ask if I've shown this to Ms. Cracher, if the court would consider looking at a photo of this to see how realistic this looks. I do think it's important when we talk about this to realize that. If there's no objection from defense.
No objection.
It's not labeled or anything, Your Honor, and I'm not admitting it, but I just want the court to see the firearm that was recovered. I didn't say the weapon. I didn't say firearm. I should say weapon. In my experience, this looks like a Glock, Your Honor, and honestly, it is amazing to me how realistic it was. No orange chip.
The court, upon receiving the people's motion, they've indicated, read the motion, reviewed the swear to. I also reviewed the arraignment so that I could fully understand what information the magistrate may have had at the time that the decision was made. I tried to give deference to the magistrate's decision regarding this. I will be quite frank with you, it is impossible for this court to do that in this case. The bond as set in this case, with all due respect to the magistrate, it's illogical to me. It makes no sense. I have someone, as I previously indicated, who is on or under sentence on a CSC 3, has not complied with the conditions of that probation. How would I even believe that that individual would comply with just conditions on bond on a capital case times 3? It doesn't make any sense to me. Further, that there is an indication, and I'm not sure why this was not taken into account. There is an indication that this might be a ring of individuals involved, some of them juveniles, and so that this not only is some isolated incident, but that this defendant may be involved in effectively a criminal enterprise that clearly would jeopardize and pose a risk to the community at large. I think it's, and it pains me to say this, that this bond virtually is illegal. Because, first of all, he's on bond and commits these offenses. Secondly, at the swear to, it was very clear that all of the elements necessary given this charge, all of the elements there regarding the presumption or of guilt or the likelihood of conviction were there, that quite frankly, I'm not sure why his bond was not denied. We don't, in a lot of cases, get to see that, or certainly not at the arraignment stage, wouldn't be able to make that finding that this likelihood of conviction is there. This one is very clear. He's caught on video. For those reasons, and having reviewed everything that I have, I regrettably but don't have any other option but to say that the setting of a personal recognizance bond in this matter, given these charges, given what I know about the case, and having reviewed everything, is a clear abuse of discretion. The court will vacate that and will reset the defendant's bond. I will leave the conditions that were set by the magistrate in place, but in terms of the monetary amount, I will reset the bond in an amount of $500,000 cash surety.
Before we consider 18%, Your Honor. Thank you, Your Honor, for considering that. Just had to ask. Thank you.
Thank you, Your Honor. I will also let the court in the schedule for probable cause conference in 6 days.
Yes.
And discovery continues in this case and the investigation continues. And I do believe that we may have additional information by the time for the probable cause conference where the people may wish to revisit bond and our groups become even stronger to request that bond be denied entirely. I do think that's a possibility in this case, but I don't know it for sure.
Understood.